informational hearing that provides an overview of the California Environmental Quality Act. We will then convene our legislative hearing and start with a special order of business, which will be SB 122 by Senators Jackson and Hill, which addresses Environmental Quality Act. Today we have 13 bills. There are three bills that are on consent calendar. My legislation 207, Ms. Galgiani's, Senator Galgiani's SB 348, and then the committee's omnibus bill, SB 662. For the public, Senator Stone, the author of SB 143, has removed the matter from today's agenda. And with that, I'd like to convene our informational hearing on CEQA. It goes without saying that CEQA is a complex procedural statute that was established 45 years ago. I think many in the public lose sight of the fact that this is a procedural piece of legislation. We jump into the meat of other statutes that provide guidance for decision makers. But it's the backbone of the state's environmental body of law. Today's informational hearing will provide us with a broad overview of CEQA so that we have a stronger base of knowledge on CEQA legislation when CEQA legislation comes before us. We'll hear from three experts accomplished in the CEQA arena. Now, our first speaker will share with us the history of CEQA, as well as explain how the Act intertwines with other environmental laws. The second speaker will walk us through the basics of the environmental review process. And finally, our third speaker will talk about recent legislation, the CEQA guidelines, and the role of the state clearinghouse. With that, I'd like to welcome our first speaker, Professor Rick Frank, who's come here from the University of California at Davis School of Law. After Professor Frank, we will like to have our second speaker, Thierry Rivas-Plata, of the Association of Environmental Professionals, and that will be followed by our third speaker at today's agenda, Christopher Calfee, who's with the Governor's Office of Planning. Good morning, Professor.
Good morning, Mr. Chairman. Thank you for this opportunity to testify. And I have copies of my written testimony with me if any are needed for members or staff. I'm a professor of environmental law at the University of California School of Law. I've been there since 2010. Previously, I taught the same subject matter at the University of California at Berkeley School of Law. In the course of those stints, I have taught CEQA to a number of students at both law schools as well as to other groups of attorneys, planners, and citizen groups. In addition to my teaching at UC Davis, I head the California Environmental Law and Policy Center, which does a lot of work on a variety of environmental issues. CEQA has been prominent among them. Several years ago, my center hosted a conference commemorating the 40th anniversary of the California Environmental Quality Act, which brought a number of legislators, decision makers, executive branch officials, and judges to talk about the history of the law and the prospects for its future. And I've also had the privilege of participating in several convenings with, including with one of the speakers you'll have in a moment, Mr. Calfee at the Governor's Office of Planning and Research, on efforts to appropriately implement recent CEQA legislation. Finally, before becoming a full-time academic, I practiced environmental law for 30 years with the California Attorney General's Office, and in that capacity had the opportunity to litigate myself many CEQA cases, both defending state agencies in a variety of capacities and also bringing CEQA lawsuits on behalf of those agencies, and in the Attorney General's independent capacity on behalf of the people of the state of California. Well, turning to the history of CEQA, before we get to the bill, we have to take one step backwards, because in 1969, the United States Congress passed by bipartisan wide majorities the National Environmental Policy Act, and that legislation was signed into law by then President Richard Nixon on New Year's Day, 1970. NEPA, as it's known, was important because that was the first of what was to become a torrent of federal environmental laws over the next decade, which 4 decades later remain the backbone of our federal environmental system. Coming back to California, knowledgeable about what had happened with the passage of NEPA, and also well aware of the fact that just a year before, in January of 1969, California had suffered a major oil spill off the Santa Barbara coast, a blowout of the Unocal platform. Those events were quite memorable. Additionally, we had the first Earth Day convened by then Michigan U.S. Senator Gaylord Nelson on April 22nd, 1970. So there was a great deal of thinking, really for the first time in any systematic way, about environmental issues. And the California legislature responded. Then Assembly Speaker Bob Monaghan convened a special panel of the legislature to investigate and to report back to both houses of the legislature whether and what types of environmental legislation the state of California should enact. And I should state parenthetically that in 1970, both houses of the California legislature were controlled by Republican majorities. The committee, that special committee, did report back and reported on several proposals, including an environmental Bill of Rights that would have amended the California Constitution. While that was not successful, in hindsight, by far the most important recommendation was the recommendation of the Select Committee that a California Environmental Quality Act, a so-called Little NEPA statute, be enacted here in the state of California. And that legislation, again, here in California, passed easily with bipartisan wide majorities and was signed into law by then California Governor Ronald Reagan. It took effect on January 1 of 1971. Like NEPA, CEQA can best be described as a look before you leap law. That is, to provide, in case of CEQA, state and local decision makers an opportunity to be aware, be informed of the environmental consequences of decisions that they were about to make, and so they could factor that into their analysis. CEQA, like NEPA, has two basic objectives. The one is the one I just mentioned, to inform and help decision makers understand the environmental consequences of the decisions they make on projects coming before them. A second and equally important mandate of both laws is to provide the interested public the opportunity to understand the environmental issues surrounding a particular issue in order that they can participate in a more informed way before state and local governments regarding projects. To this extent, and as the chairman noted, CEQA, like NEPA, is a procedural statute, a full environmental full disclosure statute. Significantly, however, CEQA goes one step further and has some significant substance, because in addition to those two informative goals, CEQA requires that state and local decision makers, to the extent feasible, adopt environment alternatives or mitigation measures designed to mitigate or avoid identified adverse environmental impacts of proposed projects to the extent it is feasible to do so. And over the years, I might say, California was one of the first states, if not the first, to adopt a so-called Little NEPA statute. Most other states in the United States have adopted this law, similar laws, as have a number of nations around the world, including India and China. So this is the most imitated and replicated environmental law of any type in the United States and across the globe. CEQA in 1970 and 1971 as a statute was very different than it is today. First of all, it was extremely short. It consisted of 4 pages, and 2 of those 4 pages were legislative declaration of legislative findings in terms of why the legislation was necessary. Over the 45-year history of CEQA, that has changed a great deal. The statute has grown like Topsy. It is now over 135 pages in length. The implementing CEQA guidelines, which are the responsibility of the Secretary of Natural Resources and the Governor's Office of Planning and Research, and about which you'll hear from Mr. Calfee in a moment, are even longer. The CEQA guidelines implementing CEQA are over 200 pages in length. So this has become a much more complicated statute than it was initially. CEQA initially in 1970 and 71 was not controversial. That may come as a surprise to this committee. It was not controversial at all.
Ronald Reagan?
Exactly. Ronald Reagan signed the bill, and again, broad bipartisan majorities. What I dare say first made CEQA controversial was the first California Supreme Court decision interpreting the statute, the iconic Friends of Mammoth decision in 1972, where the California Supreme Court resolved an issue as to the scope of CEQA by holding that CEQA applies and requires environmental analysis not just of public works projects undertaken by government itself, but also to privately proposed projects that come before state and local governments for review and approval. This was a hotly contested issue, and the Supreme Court ruled in favor of the broader interpretation of CEQA. And parenthetically, this issue was never debated in the context of the National Environmental Policy Act, which is always applied to both public works and privately proposed projects. Be that as it may, it was that decision of the Supreme Court in 1972 which caused a number of development interests, to rush to Sacramento and seek a, quote, legislative fix to the Friends of Mammoth decision, either to reduce the scope of CEQA to only cover public works projects. Some people were calling for the repeal of the then new CEQA statute altogether. Those efforts were unsuccessful, and over the course of the last half of 1972, a legislative compromise was fashioned. That provided for codification of the Friends of Mammoth rule and the broader scope of CEQA that it does and would apply to privately proposed projects as well as public projects. But the legislature decided to only apply that aspect of CEQA prospectively after 1972. In additional compromise, the 1972 legislation amended CEQA to impose rather draconian statutes of limitations, that is, statutory deadlines by which CEQA lawsuits would have to be filed. And the statutes of limitations amended into CEQA in 1972 are, in my experience, the very shortest statutes in all of California law. In some cases, they are short as 30 days, meaning that those unhappy with a CEQA decision of state and local government must file a lawsuit to challenge that administrative decision within 30 days of the agency's final action. Well, Friends of Mammoth, I think, really set the tone for CEQA in the state in several important ways. It is, in my opinion, California's single most important environmental law, and that's due in significant part because of its cross-cutting nature. And I'll talk about that in more detail in a moment, but suffice it to say that whereas we have air pollution statutes and toxic waste statutes and more recently statutes specifically addressed to climate change, CEQA potentially applies across all those subject areas. Second, the legislature, ever since 1972, in response to the Friends of Mammoth decision, has repeatedly revisited CEQA and has amended it, recalibrated it almost on an annual basis, often through multiple bills enacted even in a single exception. Some of those involve exceptions from CEQA compliance for certain favored projects. One of the first and most famous was an exemption from CEQA allowing Los Angeles to prepare for and host the 1984 Summer Olympics. More recently, some of those are to expedite CEQA processes, not to exempt projects from CEQA, but to expedite the process. And recent legislation, with which I know some of the legislators here have personally familiar, have sponsored, and the legislature has enacted proposals to expedite CEQA review of infill projects in urban areas. And again, I think Mr. Calfee may speak to that. I dare say that despite efforts from environmentalists on one side and development interests on the other side to propose and urge dramatic reforms and changes to CEQA, the legislature's approach over the last 45 years has been incremental rather than dramatic changes. Another key feature of CEQA is that all three branches of state government have important roles with respect to the statute. I've already spoken to the legislature's ongoing effort to oversee and amend the statute when that's been perceived to be necessary. The courts, I'll talk a little bit more about CEQA litigation. CEQA is also the most heavily litigated environmental statute by far in California, and the courts spend a lot of time resolving CEQA cases, including the appellate courts. And 45 years into CEQA's history, we now have a voluminous set of case law courts interpreting and applying CEQA. I dare say, though, on a day-to-day basis, it is the executive branch of state government, and along with local governments, that are responsible for implementing and complying with CEQA and have, through CEQA, incorporated environmental review as across a broad array of the projects that they review and substantively decide on. Numerically, local governments, the state of California, counties, cities, special districts, have the lion's share of CEQA compliance. It is an important principle applying to state government, both with respect to its public works projects like the high-speed rail project, the Bay Delta Conservation Plan, aka the Twin Tunnels proposal, but on a day-to-day basis, most of the CEQA analysis is conducted by local governments up and down the states. The other issue I've been asked to briefly speak to is how CEQA works in conjunction with other laws. Generally, CEQA works congruently and in parallel with the substantive laws. For example, if a proposal is to, by a local government planning commission to review and approve a subdivision, they will do that in conformance with the California's longstanding planning and zoning law, but CEQA has to be complied with in conjunction with that. So it is a parallel process that is undertaken by local governments in that instance and by state and local governments generally. There are certainly some instances in which a proposed public or private works project, there's no reasonable dispute that, that such a project will not have the potential for a substantial adverse change to the environment. In that case, the statute is explicit that further CEQA review or compliance is not required. There has been some streamlining by the legislature to integrate substantive regulatory programs and CEQA review. In those cases where an existing agency, and in this instance it's mostly state agencies, are conducting their reviews under their enabling legislation that already includes environmental analysis, where those substantive laws serve as the, quote, functional equivalent of the CEQA review process, those agencies can seek from the Secretary of Natural Resources and obtain a so-called certified regulatory program status so that they don't have to prepare independent CEQA documents and enforce CEQA independently. Two brief examples: the California Coastal Commission, in its review and approval of local coastal programs of the California Coastal Act, has been approved in that regard and needn't prepare independent CEQA guidelines. Similarly, the California Energy Commission, as part of implementing its one-stop siting process for large thermally powered power plants, similarly has that process, so it isn't required to prepare the documents that you'll hear about in detail for subsequent witnesses. Nevertheless, in recent years, some critics of CEQA say that it is unnecessarily duplicative and redundant of substantive review, and they have argued that at least where those independent statutes like an air pollution emissions law creates substantive numeric quantitative standards, that CEQA compliance should not be required. Again, in recent years, the legislature has not adopted or embraced that proposal. Again, CEQA is always controversial, always on the minds of all three branches of government. Here at the state level, I think we're hearing about it most in connection with the two biggest public works projects in the recent history of the state of California, high-speed rail and Bay Delta Conservation Plan. So I'm confident it will continue to be a part of your legislative agenda for years to come. That concludes my prepared remarks. I would be happy to answer any questions that members of the committee may have.
Well, this is an academic discussion, so we will have questions. Senator Jackson.
Thank you very much, Professor. Very much appreciate that historical view. I think it does help to kind of emphasize the pluses and minuses and the various groups and interests that seem to come together and clash or agree. Mostly clash, I'd have to admit. But a couple of questions. Isn't part of the, well, it's my understanding, and I'm carrying a CEQA bill that I guess is going to be heard right after this minor efforts to tweak CEQA, but that only about 2% of all CEQA, issues are resolved through litigation, so that 98% of them actually do resolve at the administrative level. Is that accurate?
That is accurate, and I'm glad you brought that up because that's in my prepared testimony, and I omitted reference to that, that contrary to some perceptions, the vast majority of CEQA compliance is handled smoothly and without substantial controversy, and certainly without litigation at both the state and local levels. Litigation challenging CEQA decisions of government remain the exception rather than the rule.